email, whether it's been printed or not, whether it's been shared with others or not, and the status of the sensitivity of that information. But it also often does include, yes, interviews with individuals. As I said, I can't tell you on this account, I would not and do not hold these investigations personally, but I'm happy if I'm able to, and there are no constraints upon it to share information to be anonymised, but the procedure that we followed.
Thank you very much, Permanent Secretary. That's a very helpful response. Would you be able to tell us either now or subsequently whether the First Minister's Chief of Staff, Liz Lloyd, was interviewed as part of that inquiry?
As I said, I can't tell you now, and I don't know if we're going to be able to give individuals details as part of what I can share, but I will share all I can on the inquiry on two counts. One, what is the procedure that we always follow? Because there is quite, as I mentioned earlier on, there is a formula to the investigations that are undertaken because they are both technical and digital as well as individual. So I'll happily give you that. And if I am able to put more flesh on the bones of this particular investigation, I will do. But as you know, I'm under constraints, as we all are, to do with identification of individuals and data protection. But I will share whatever I can.
Thank you, Permanent Secretary, and thank you, Convener. I've no more questions.
Thank you. We'll move on to Jackie Baillie, please.
Thank you very much, Convener, and good afternoon and welcome back to the committee, to the Permanent Secretary. Can I start with just a follow-up to Murdo Fraser's questioning, because I'm curious to know whether the names of the complainers would have been contained in either the investigating report or indeed in your decision makers report, and further to that, could you tell us who therefore would know the actual names of the complainers, and would it have been possible for a special advisor to know the name? And I'm quite content with short answers given the time you've already been with us.
So no is the answer to your first question. Ms A and Ms B was the titles that were given from the very beginning. Indeed, I did not know the identity of either until I had contact with them, which I've already described, in early March. So there was no disclosure of names at any point.
Could you therefore tell us, who in that very tight circle I think you're about to describe would know the names of the complainers? I'm assuming it's a handful of people.
At the most, yes.
Okay, could you possibly, if not now, certainly write to us, tell us who that was? And I'm specifically asking, would it have been possible for a special advisor to have known any of the complainants' names?
I'll happily come back to you with who might have known, but you're absolutely right in your assertion that it was, as it should have been, a very small number of people who were alert. And as I said, I myself did not know, quite rightly, the identity of the individuals until I met and spoke with them in early March. So that gives you an indication of the care with which we were taking. In fact, I still don't know the identity of one of them, and I've never met them. I'm not sure that I ever will. So it was a very, very important part of the trust from the individuals and the competence of the procedure that we maintain very tight understanding of individuals, not just of complainants, if I might say, but also of witnesses too.
If you could write to us specifically with the information of that tight circle and confirm in writing whether it would be possible for a special advisor to have known that information, I think that would be most helpful. Can I move on to looking at this whole question of a duty of candour, because some of the documents released to us from the Davidson report suggest that on the 2nd of November, external counsel were required to stress the importance of the government's duty of candour, and that on November the 6th, 2018, in the Court of Session, Lord Pentland directed that he expected full candour and disclosure from the government. So bearing that in mind, could you perhaps tell us why you have never previously revealed to us in all your appearances before this committee the information that not one but both of your external counsel threatened to resign to walk off the case unless you conceded it by the 3rd of January 2019?
So I think you're asking why I didn't, or why the Scottish Government didn't share views of Council and views expressed by Council as part of previous sharing of information. And I would point you to the discussion and dialogue that has been taking place between the Scottish Government and Scottish Government ministers and the committee about how and when to share legally privileged information, and indeed the rules and responsibilities of that govern law officers' roles as well. And this would fall into that category. But of course, the reading room has enabled a wider amount of information to be shared with the inquiry than had previously been signed up to by the government.
We could argue whether that's sufficient, but I'm not going to waste time doing that. We did in fact get hints of an answer from Paul Coquette when he appeared before the committee, which clearly is now confirmed to us. So let me press you again. You have a duty of candour. I think that's quite an overriding duty. Why did you not tell us this information in terms of that duty of candour?
I think I've already said why this information had not been shared by the Scottish Government. I think the other point, which seems to be implicit in what you're saying, but tell me if I'm wrong, is I mentioned earlier on what the reasons were, what the rationale was for my taking a decision to concede the JR, to concede the judicial review, and the factors that I took into account. I won't rehearse them again because I think I went through them in quite a bit of detail. But the main issues that I needed to take into account was legal advice, and I would have been irresponsible not to take account of the composite legal advice. And that was when I was in the process of commissioning that information on the 21st of December. And that's an important date for me because it was the time at which I decided that I would need to take a decision about whether to proceed or not. And I've been very upfront, I think, at this session about what the factors were that I took into account in taking that decision.
Let me go back then, because there are other important dates I would like to discuss with you. And in the same kind of terms of the duty of candour, let me turn to external counsel. When did they tell you that on balance you would be likely to lose? Was it in October? Was it at the consultation meeting that was held with Council on November the 13th, which we know you personally attended, along with the First Minister and the Chief of Staff, or was it even earlier? And I'm not asking about composite legal advice, I'm asking specifically about external counsel.
But I am talking about composite legal advice because that is what
I'm asking you about external legal counsel.
That I can give, which is that I always took composite legal advice. It would have been remiss for me to only have listened to one voice. At every stage, the legal advice that I was provided was complete and thorough and from a variety of sources, and that is quite right and quite appropriate. And indeed, at the time of the time that I think you're referring to, Ms. Baillie, at the end of October or around the middle of time of October, was a really important point, because that composite legal advice was considering a new aspect, which was it possible to interpret paragraph 10 differently? Was the interpretation that we had laid on it, and that was within the spirit of its being drawn up, somehow able to be interpreted differently? And that prompted
if I might interrupt, because
a whole standard work undertaken.
That is not my question, and the Permanent Secretary understands that. My question is very specific. It's not about composite legal advice. It's about the advice from senior counsel, and I'm asking that did they say that on balance the Scottish Government would likely lose in October? Was that when they told you, or was it at the meeting on the 13th of November, attended by them, yourself, the First Minister and the Chief of Staff?
We had discussions with Council and with our legal advisors on the prospects of success throughout this period, as I have always said, and that included those dates. And I listened carefully to that advice, as did the First Minister. And those sources of advice were what guided us through and contained and continue to inform our decision that the case was stateable until it was not, which is the point at which I was asking for advice from a variety of sources again on the 21st of December. Up until that stage, the advice that I was being provided with and from which I did not depart, that composite advice, was that the case was stateable and that it was defensible and should be defended. And I think you heard that from the Lord Advocate himself on his evidence on the 17th of November.
I think you perfectly understand what I'm trying to pursue with you. It is not a question of the composite advice, which would include advice from Scottish Government lawyers. It is a question of what external senior counsel were telling you. And I am asking again, based on just that advice, did they, in October, say to you that on balance you would be likely to lose?
I cannot confirm legally privileged advice. I can say, as you know, Ms. Baillie, I have constraints about what I can and can't say on that score, and that is still a subject of some consideration between the committee and the Scottish Government ministers. What I can say is that I listened carefully to all legal advice from all sources at every stage, every single stage of the procedure, not just during the judicial review, but I had really careful and really important role and responsibilities to undertake, which mean it was demanding me to take that legal advice. I cannot uphold the Civil Service Code without listening to that legal advice. I cannot be, I could not be responsible in my role as Principal Accountable Officer. And that included, of course, that included external counsel advice, but it also included advice from Lord Advocate and from the Scottish Government legal team.
Thank you for that, but you haven't answered my question, and that is unfortunate. So let me move on and see if I can make progress elsewhere. In terms of Canada, the first revelation to Mr. Salmon's legal team of any issue with the investigating officer was, I believe, the 5th of November 2018. Yet you have made much, as I recall in your previous appearances, that this issue wasn't in Mr. Salmon's pleadings to the Court of Session. Can I ask you, how could they have been if he wasn't aware of them, if your team didn't tell him about them?
I think it's for Mr. Salmon to decide and to share with you the basis on which the grounds of the judicial review were drawn up by his team. As I think we said earlier on the unlawful and unfairness of it.
Excuse me, I'm going to interrupt here, Miss Baillie and Miss Evans, because when you're both talking, it's particularly difficult when we're online to interrupt people. When you're both talking, you just turn into a big bubble of sound. So whilst I can understand frustrations if it's felt that questions are not being answered, and I can understand frustrations if one feels that the questions aren't what they should be, I think the only way to deal with this sensibly is to listen to the question, then listen to the answer, and then have the disagreement if necessary, one by one. So I can't remember who had started that exchange, but I think I'll go back to Miss Baillie, please.
Thank you very much, Convener. Can I say that this serves to highlight, for me at least, how unsatisfactory having virtual sessions in, and I see you nodding in agreement. I think this is something we will obviously discuss as a committee later. I do apologise for interrupting, but I am very keen to ask very fixed questions and get short responses to them. Okay, let me move on. Given that Miss McKinnon was perfectly open about her activities as the investigating officer, why didn't your civil servants tell the courts until the 5th of November, and indeed even your own counsel until October 2018? Why so late?
Why did they not tell them what? Sorry, I'm not sure about what they...
About the activities of Miss McKinnon as the investigating officer, that she'd met with complainants beforehand. Why was that never revealed?
So it wasn't that it wasn't revealed, it was asked about at that point. That was at that time at the end of October and beginning of November, that became apparent from the legal analysis that a different interpretation was possible. And at that point, it was requested that a number of civil servants provide information to illustrate the intention behind that role, which, as I've said before, has been talked about a lot around this table, about what was actually meant by the spirit of paragraph 10, and also what evidence could be brought to bear to show that. And that was when that commission was undertaken, during quite a bit of November and actually still into the information gathering stage at the beginning of December. And as a result, pleadings were adjusted. We voluntarily provided that information to the other council, as you know.
So who asked about it and when? When did paragraph become open to interpretation?
The legal team was asking Judith and others, I think James Hines, whose note you've seen of 2nd of November, about the intent and about the information to illustrate the intent and the level of contact and why that was part of the implementation of the procedure. That was from the beginning of November onwards and continued into the beginning of December.
But your own council knew in October, did they not?
I think it was the 29th of October that this was crystallised. I maybe need to check that, but it was around that time where additional advice and information was sought by the legal team to illustrate our interpretation of that paragraph, how it had been applied.
But the first disclosure, was it not round about the 17th of October when Miss McKinnon was interviewed by Junior Council?
I can't be exact by the time, but I know that it was under discussion at the end of October, absolutely, and there was a period of time throughout November, as I've said earlier, where significant amounts of information and requests for further information to illustrate the nature of the role and the intent behind the role was being established.
Okay, thank you. Can I move on? Some of the documents received showed us that you, and this has already been covered, but as the impartial decision maker, personally met both complainers in March 2018. I understand before Mr. Salmond was informed about the procedure. Given your duty of candour and given the strictures of Lord Pentland, why was this meeting not disclosed?
To who?
To anybody, to the courts, to Mr. Salmond.
I don't believe that it was particularly concealed, but the point about this was that it was part of the pause point in the procedure to allow me to be able to really touch base with the individuals about duty of care. There was no discussion about content or anything else. It was after I had taken my decision. That was all that the meeting was about. I can't say finitely whether or not the Commission for Information included that in it or not, but there was no attempt to conceal, but it would be something that would be naturally talked about. It was part of the duty of care for the complainers.
Okay, so it wasn't concealed, but neither was it disclosed. So that's unfortunate given the duty of candour that exists. Let me move us on. You said that it's appropriate, and I don't want to misquote you, but it's good practice to actually work with the complainants. I understand that. But can you point to any clause in the procedure which says the decision maker is meant to meet the complainers? And the reason I'm asking you this is, I think in your second appearance before the committee, I think you said to me it wouldn't be appropriate as the decision maker if you had contact with the complainants. So if your policy was ruled unlawful, procedurally unfair, and tainted by apparent bias because the investigating officer met the complainers before it started, would that have happened on the discovery that you as the actual decision maker met them partway through?
So I think we could get into semantics, Ms. Baillie, about what was actually ruled on the procedure, but it was about a ruling of apparent bias. Many of the other earlier points that had been raised as part of earlier judicial review grounds were not discussed and were not ruled on. However, the point you're making is when I was previously at this committee, I was talking about the early stages and particularly about the development of the procedure. and that I had not had contact with those who were raising concerns at that time. As soon as they had raised complaints, that would have put also a constraint on my contact with them, quite rightly. However, as I said earlier on, the reason that I touched base with them at the time I did, which is the week of the 5th of March, I think it was probably a day, maybe some hours before Mr. Salmond was made aware of that point that I had reached in the investigation. The reason I met with them at that point was because I had taken a decision. It was not one that I was asking them about or they were involved in or that they could have influenced. I had taken a decision, and that pause point in the procedure allowed me to touch base with them about my own duty of care and the organisation's duty of care for them too. So it was quite appropriate, and there was nothing in the procedure to say that that is not the case. I took my responsibilities for them, and still do, very seriously, but I equally was bound by my responsibilities as a decision maker not to discuss that with them, and that pause point in the procedure at that point allowed me to do so, to talk to them without having been compromised on my decision-making responsibilities.
Okay, the Lord Advocate has told us that the collapse of the case was more than just the wording of Clause 10, but the assumption of perceived bias in common law. Do you think a reasonable person might have a problem with a supposedly impartial decision maker meeting with just one side of a dispute and then not revealing this to the other?
So I think if we're talking about the basis on which the concession was made, it was very clearly that it was the evidence that came forward at a very late stage in December, which would have made it very difficult for us to rebut an inference of apparent rather than actual bias. So it was about apparent, not actual bias in the way that the investigating officer's role had been implemented. And we still stand by that. Clearly there is more to learn from it, but that was the basis on which this was being, the concession on which I took a decision was made.
I mean, it feels like we're dancing on the head of a pin here, but you know, I'll accept what you're saying to me. Let me move on, because I understand that a search warrant was served on the Scottish Government by the Crown Office perhaps just over a year ago to secure documentation in relation to the criminal case against Mr. Salmond. I understand that that warrant specified recovery of all documents about any meetings between you as Permanent Secretary and the complainers. Therefore, were the documents about your meeting with the complainers furnished by the government in response to the search warrant, or were they not?
The search warrant was complied with. It included a copy of the decision report. And if there are allegations or concerns about whether or not the Scottish Government complied with the warrant, I am not aware of them. If they are, then we would need to respond to them accordingly. But when the warrant was served, which was in September 2019, is my understanding, it included some very specific requests for information, and we complied with those, and that included my decision report.
Okay, let me take you back, because I asked you about the judicial review. I'm now asking you about the criminal case, and I'm saying to you that the warrant specified recovery of all documents about any meetings between you as Permanent Secretary and the complainers. Okay, it's very clear. So were the documents about your meeting with the complainers that we've just spoken about furnished by the government in response to the search warrant, or were they not?
I can't tell you that at this stage. I could go back and ask the people who were responsible for complying with the warrant, but I can't tell you chapter and verse of which documents were provided.
That would be very helpful if you could return to the committee. That would be very helpful if you could write to us answering that question. Can I just ask, because right at the very beginning, I recall you saying to us that you really didn't have that much to do with the policy, that it wasn't really your procedure at all. And today you've said it's the Scottish Government's procedure. And I understand that. But when I look at documentation from you, a letter of the 21st of June 2018 from yourself to Levy and McRae, you say, and I quote, the procedure was established by me, not the Scottish Government, but by you. And when Angela Constance asked you on the 17th of November, she did, I think, describe your role as the common denominator of the whole saga. You said it wasn't really your procedure at all. So when did it stop being your procedure? If it was the Scottish Government's procedure, at what meeting of Cabinet was this actually agreed? Was it decided on? It's certainly never been debated or disclosed to Parliament. So I'm kind of curious as to know, when was the procedure discussed and approved by the Cabinet?
It's an employment procedure. So an employment procedure, and I think I've said this earlier on, would not go to Parliament for approval. It was an employment procedure that emerged from a specific commission from the Cabinet, and it was signed off by the First Minister I think, on or around the 20th of December. Now, I think we're also in danger of splitting hairs here. I, as a civil servant, as you know, constitutionally, civil servants don't exist. The procedure that I was responsible for ensuring was enacted and produced as a government procedure, was in response to a Cabinet commission. And it was and is a government procedure. I am therefore bound by it because, as you know, as a civil servant, I serve the government of the day and I serve the government commission.